Welcome to our fifth COVID-19 webinar. I'm pleased that the State Bar, thank you, Anita and Mike, especially for logistically being able to put these together as we've come up with ideas. We've done 5. We've got one this afternoon at 1 o'clock, dealing with scams with Mr. Keith can speak. He's on behalf of the FTC is where he is employed, speaking about scams, and it should be excellent. So 1 o'clock. But thank you, Anita and Mike, for helping us put these on. We've put these on just in the last few weeks, and hopefully they've been educational and if anything, inspirational and maybe even encouraging to all of you during these challenging times. We will have probably a record number here today, which is wonderful, of 900 or more attorneys. We've had, as on the other ones, normally 700 or 800. So I'm glad that we've been able to put these on. Be on the look with your bar blast. We don't have anything announced yet, but we hope over the next few weeks, as the courts are physically reopening, that perhaps some circuit court judges having conversations in this fashion as well with you all. So stay tuned. I wanted to do a really quick, take 1 minute, sort of a PSA. I read something this morning and it just prompted me to want to encourage our members to, I know it's difficult now to think about doing pro bono service for others, but there are a lot of folks out there that are in need of assistance now, and certainly as things are moving forward, that can't afford legal services or access to justice. And I wanted to put that on your radar. There is a new rule, and hopefully this can help to some extent or encourage you all. Regarding CLE, you can obtain 3 hours or for 1 hour of CLE credit for 3 hours of pro bono service. And Anita will correct me if I'm wrong, but I think you can earn up to 6 hours of your CLE credit in a reporting period for pro bono service. So just wanted to put that on your radar if you hadn't heard about the new rule, to encourage us all to hopefully get out there and help those that could use legal assistance and can't afford it. So in addition to assisting you all with your practice with these webinars, I think have been a means for our members to connect with each other. I mean, obviously we have 900 attorneys on here. Also for you all to connect with the bar and for the bar to connect with you. But as importantly, and I'm really pleased that today we can now use this as a means to connect with our judiciary. So I'm pleased that our Supreme Court is joining us here today for this conversation of sorts regarding our state courts during these challenging times. And hopefully this is just the first of many of these that we will host with you all throughout the course of the year. So at this time, I will introduce just briefly our panelists and our moderator. Certainly you can go to the Supreme Court's website for more complete bios. But at this point, let me introduce our panelists. We have Chief Justice Tim Armistead, was appointed and then elected to the Supreme Court in 2018 after serving for more than 20 years in the West Virginia House of Delegates, including 4 years as Speaker of the House. He is a graduate of the University of Charleston and the WVU College of Law. Justice John Hutchison was appointed to the Supreme Court in December 2018. Prior to joining the court, he was a circuit court judge in the 10th Judicial Circuit in Raleigh County for nearly 25 years. He is a graduate of Davis and Elkins College and the WVU College of Law. Edith Nash Geiser was appointed Clerk of the Court of the Supreme Court of Appeals in 2017 after having served as Deputy Clerk of the Court for 14 years. She is a graduate of Wheeling Jesuit University and Duquesne University School of Law. Edie is currently President-elect of the National Conference of Appellate Court Clerks. Our moderator today is Justice Beth Walker, who was elected to the court in 2016 after more than 25 years of private practice. She is a graduate of Hillsdale College and the Ohio State University College of Law. Thank you, Justices, for joining us. I'll turn things over to Justice Walker.
Thank you, Monica, and thank to you, the governing board of the State Bar, to Anita, to Mike, to everyone at the State Bar. About a week and a half ago, I attended one of your prior COVID-19 webinars, and I was amazed, although not shocked, that you all had developed this amazing platform to communicate with the bar. and that you had, developed the ability to, broadcast information to hundreds of lawyers very efficiently, very effectively. So I went back and talked to my colleagues and said, this would be a great opportunity to put out there some information about what we've been doing and what we plan on doing in terms of COVID-19 and the pandemic and what we've been doing with the judiciary. So thank you for this opportunity and for providing this excellent platform. And I'd also like to thank everyone who's joined us. We know this has been difficult. And there are a lot of unknowns. We're hoping that we can illustrate some of those and knock some of them down, but as lawyers and as judges, we like to plan, and this has not been an easy time to plan. This kind of hit in March, and we have been reacting ever since, hopefully in a way that not only fulfills our responsibility to keep the courts open, but also keeps our employees safe and does not expose any of you or your clients unnecessarily to any kind of risk while still getting our work done. So that's been our challenge, and I'm excited to have the three panelists here. We've got a little bit of a program. I will be checking my email, and we've already gotten some questions in, which for those of you who emailed yesterday, we're going to try to work your questions into the program. For those of you who are emailing today, we'll try to get them answered. And if we don't have them answered, I will make every effort to email you back. I'll either email you or Edie or someone else from the court to answer your question to the extent we can. Of course, the big disclaimer, so that none of you have to repeat it, is we're certainly not going to comment on any questions of law that might come before the court. That would be outside of our what we can do under the rules of judicial conduct. So with that, let me start with the Chief. And Chief Justice Tim Armstead, why don't you tell us a little bit, give us an overview of what the Supreme Court, what we've done in response to the pandemic.
Sure, thank you, Justice Walker. And first of all, let me also express appreciation to you, Justice Walker, and to Monica and Anita and the State Bar for putting this together. I think it's a tremendous opportunity for us to be able to share a little bit of what's been going on and what we anticipate is going to be going on over the next few months. So with that, let me just start. As Justice Walker said, it is certainly a balancing test that we have to undertake in order to try to fulfill our obligation and our duty to keep courts open and working in our state, while at the same time keeping the parties, the attorneys, the litigants, the public, the judges, all safe and healthy. So that's been the work that we've been doing over the last couple of months, trying to appropriately balance those two factors. And I think that has been a moving target to some degree, a work in progress, one might say. And so I did want to just kind of review a little bit about where we've been in that process. We started with some protocols that we put forth on March 12th. So we're almost 2 months from that. It certainly seems, and I'm sure it does to everyone, seems longer than that we've been addressing these issues. But it was a little less than 2 months ago that when the COVID-19 epidemic really started throughout our nation. It hadn't quite started in West Virginia at that point, but we wanted to plan ahead, and so we put in place some protocols, primarily dealing with how our court employees and parties and litigants should address the situation if they have any type of symptoms of COVID-19 or they have been exposed to someone who might have those symptoms or have been tested positive. So those dealt with personnel issues, but court operations. And so we started with that on March 10th. As the epidemic started to reach West Virginia, which was a pretty short period of time, on March 16th, we entered an order originally that basically stayed civil and criminal trials and jury orientations. And we we identified some emergency matters that we felt were particularly important to proceed. We certainly wanted those to proceed as much as possible by telephone or video conferencing, but we understand, and you know, I've said this a number of times, simply because of the pandemic that we're dealing with, people do not stop committing crimes. People do not stop, unfortunately, abusing and neglecting children. People do not stop engaging in domestic violence. So, and many other areas of the law where we simply needed to proceed, even though we were dealing with this epidemic. So what we did is identify some of those areas where, for example, I mentioned some domestic violence petitions, child abuse and neglect, and other matters that we felt like needed immediate attention. So that was our first order on March 16th. Edie is putting up a copy of a portion of that order. And what we did there was we also extended certain deadlines. So we'll talk a little bit about that. On March 22nd, we actually spent most of the weekend. All the justices, a number of members of our staff, we have a couple of attorneys, Keith Hoover and Brad Smelzer, have been just tremendously helpful in addressing these issues, along with our clerk, Edie Geiser, and others who helped work with us throughout that weekend. On Saturday and Sunday, the full court was on a number of different calls, along with circuit judges, representatives of the family court judges, magistrates, to address the specific needs that we needed to put into an order. And so we did then produce an order on March 22nd that further outlines some of those emergency matters, and also, you know, stayed statutes of limitations, stayed certain deadlines through our rules, and those are outlined in those orders. Those orders are on our website if anyone wants to take a look at them. I assume that most of you probably have already looked at those in terms of guiding how you proceeded with your practices. But we put that order out on March 22nd. That was our first judicial emergency order under West Virginia Code 2-2-2. We can declare an emergency in our judicial system, and that's what we did, which gives us the ability to stay certain proceedings and to also govern what will move forward. So then after that, we realized that judges and parties and attorneys were becoming much more conversant with the use of technology, much more able to do hearings and proceedings with technology. And we were hearing from a number of lawyers as well as judges that there were certain other matters that were not identified as emergency matters that really needed to proceed so that there wouldn't be harm to the parties involved. So we extended that order to allow those types of matters, as long as, first of all, they could be done remotely through video conferencing or telephone, use telephone conferencing, and as long as the parties agreed to allow those matters to move forward. Now, we also didn't want there to be situations where parties unreasonably disagreed and just said, because they like the status quo, no, I'm not going to agree to move forward with this. I don't want the status quo to change. So we put in a provision that they could not be unreasonably, that consent to move forward cannot be unreasonably withheld.
Justice Armstead, I apologize. This is Anita. Are you attempting to share your screen, or is someone else sharing it?
That's Edie is showing some of the provisions of these orders.
Okay, thank you very much.
So hopefully people can see what Edie is putting up, some of the language that I've referred to in these orders. So then we, again, the progression of those orders led to an April 3rd order that expanded the ability to do additional matters remotely. And finally, we extended the order as things progressed. On April 22nd, we extended the order basically through May 15th. And we said that also, in addition to the provisions allowing matters to go forward if there was a risk of immediate harm to the parties or serious harm to the parties, we felt like that, again, the use of technology had progressed over that 6 weeks or so to where we could open that up a little further. As long as, again, the parties were doing this remotely, there was an agreement of the parties without any party unreasonably withholding that agreement. And so we opened that up to where, they could pretty much do any matter that could be done remotely during the remainder of this period of time. And we additionally added some things. There was some question about whether non-contested adoptions, for example, would be considered emergency proceedings. And of course, we felt they were, so we expanded that as well. In addition to that, and this will be the sort of the last issue that I'll talk about as to where we've been up to this point. We also, Justice Walker, when she was Chief Justice last year, had appointed a working group to look at our rules of civil procedure. And that working group, along with Judge Reeder from Putnam County, came forward with some very productive recommendations about some of the rules of civil procedure and other rules, trial court rules, that could be modified to assist our parties, our judges, our attorneys in determining exactly how those matters could proceed. It dealt with things such as discovery, remote discovery, and other matters such as that. And I believe Justice Hutchinson may touch a little bit on that, so I won't go too much into that. But we certainly appreciate their work in coming forward with those recommendations, and the court talked through those and adopted an order that put a number of those in place, and that was on April 24th. That is where we are. Both of those orders are currently in place, and we'll talk a little bit in a few moments about where we go from here. But that's sort of where we've been, and I want to thank all my fellow members of the court, our judges throughout the state, our family court judges, circuit court judges, magistrates. They've really come to the table and made this work in a very creative way using technology.
All right, thank you, Chief, for giving us that great overview. Next, I want to turn over to Justice Hutchinson and not only ask him maybe to highlight a little bit of what we did in the temporary order, but we also got a question or two in yesterday about some very practical aspects of moving forward that I think he can comment on. We all rely and are grateful for Justice Hutchinson's practical experience from the circuit court bench. And so Hutch, I know I'm trying to call you Justice Hutchinson, but it's hard. Hutch, I will turn it over to you.
Thank you very much. Chief Justice noted the April 24th order, which was an order that kindly expanded the scope of what we were allowing to occur. I'm now back in the courtroom. I can see I've changed that thing about 6 times. But in any event, there was a need to move forward with some civil things. We had focused in our prior orders on things like abuse and neglect, some criminal issues, including initial appearances, arraignments, bond hearings, that sort of stuff. We were able, with the cooperation of the prosecutors and the judges, to get them to start looking at, for example, folks that might be able to be removed out of the regional jails. And I think the last number we heard was we were, through that cooperation, able to reduce the jail population by about 13 or 14%, which is fantastic. But the guys dealing with civil things felt like they needed a little relief, and the group that Chief Justice talked about earlier got together and gave us some practical ways to kind of open things up. Based on what's going to happen here in the next several days, there will be a new order coming out and some things will be opening up. The chief will get to that in a few minutes, but I wanted to comment. We got some great comments on that civil litigation order. We asked for in our order for comments. We gave a period of time and we got some fantastic responses to those of you who responded with practical suggestions. We really, really appreciate it. One of the things that I wanted to touch on just very quickly, in that order, the rule 30B7 depositions essentially said you could take 30B7 depositions if both parties agreed, and there must be good cause. I think that's been misinterpreted based on the comments that we got. I think that if you go back to the language that the chief pointed out, where we were talking about agreements, and that agreement shall not be unreasonably withheld. That's where we were headed. You don't have to show good cause to take a 30B7 deposition. You have to show good cause for not agreeing to it. And so I think folks were interpreting that those comments in that civil litigation order exactly the opposite of what we intended, which was that people should move forward and be able to have that kind of discovery, and there had to be a good reason that you didn't agree. So remember that. But based on some of the things that the chief is going to talk about here in a little bit, the civil litigation order will be in effect for another couple of weeks, and then the new order taking us forward will come out, and the chief will talk about those terms in a little bit. But one of the questions we got was, when these things start opening up and we start allowing jury trials and stuff, what are they going to look like? Well, I think that you have to understand that we as justices on the Supreme Court have a great deal of trust in the circuit judges and the family court judges and the magistrates in terms of their ability to adapt. And you're going to see a great deal of adaptation in terms of what would, quote, be a typical trial. You're going to see situations based on the physical location. All courtrooms in this state are different, and the judges are going to have to adapt their policies to that. But you're going to see things like requirement for masks. You're going to see a continuing requirement for social distancing. You're going to see, so that's going to impose some things like being able to adapt voir dire. Maybe you don't bring in as many. We're not going to allow huge jury orientations. You're going to have a little bit longer process at the beginning of the trial to make sure a jury is appropriately oriented to their obligations and what's needed for them. I had a trial back in 2006 where we had to call in 400 jurors to get a panel. It was very, very important. There's the flood case. And we rented the Raleigh County Armory and had all the jurors come in, the lawyers. We had it set up so that they could do the initial voir dire and kindly weed out the panel. And then we started bringing them in smaller groups to do a little bit of limited individual voir dire. So there are going to be things like that judges have the ability to do. In criminal trials, you're going to have a greater need for the judges to be able to adapt to make sure you have social distancing, because you've got 12 jurors plus a couple of alternates. So you're going to need some room, and that may limit the public access. Judges are going to have the ability to recognize that while trials of that nature are open and our courtrooms are open, they're only open as to the extent we have space. And so judges are going to have to come up with a reasonable ability to limit access to the courtrooms to the public, but while at the same time keeping them open. During that same flood trial, we set up remote locations that we broadcast via closed circuit TV. We broadcast the trials to different locations throughout the city where we were having the trial. So, there are things like that, and we have a fantastic IT department that has worked unbelievably well with all the judges and the justices to try and make these things happen. And those folks will be available to assist if there's a need for that. Most of you understand that a civil trial these days, the people that are involved will show up, but generally no one else. but there will be situations, asbestos trials, for example. You've got huge mass litigation cases or multi-district litigation issues where the judges are going to have to be able to adapt, and the Supreme Court and the justices, the administrative office, the IT folks are going to be available to assist in any way they can to make these things happen. So typical, we're living in a new normal now, and so trials are going to have to approach a new typical, and so you're going to see a lot of adaptations, and we trust our judges to have the ability to think outside the box and figure out how they need to get these things done. I think that's pretty much about what I've got to say on the issue, because I think Tim's going to cover, I'm sorry, Chief Justice is going to cover where we're going forward here in a little bit, so I won't steal his thunder. Thanks.
Well, thanks, Hutch, for offering a few practical observations. One of the themes that we wanted to emphasize today, of course, is that even though life has changed, we will continue to rely on the local leadership of our chief circuit judges, our chief family court judges. So we can't dictate everything from the Supreme Court. That said, we're certainly going to remain responsive and put out as much guidance as necessary and is helpful. And as part of that, of course, we're using our website very actively. And so I want to turn things over to our amazing court clerk, Edie, who was the one of the major brains behind putting our arguments online here recently. But I would like her to talk about what our judicial emergency has meant for the clerk's office. And she's going to break some news because we have a new feature to show you before we turn it back over to the chief for the answers that I know you all want, which is when do the courts open back up. But in the meantime, Edie, why don't you demonstrate, talk about the clerk's office and demonstrate the resources that are available on our website.
Okay, thank you, Justice Walker. You know, I constantly say we are not reopening. We have been open. All of the clerk's offices throughout the state have been open and actually been very busy. In the clerk's office at the Supreme Court, although all of the deadlines for filing have been extended, keep in mind that we are there. There is a box outside the clerk's office door for you to drop filings. And we are accepting all types of mail. So we get United States Postal Service mail, FedEx, UPS. You can go ahead during this time if you're able. I know some people are just wanting to get back to a routine, wanting to get back to some type of a schedule. And perhaps now, before all of the deadlines that were extended come back into place, you can use this time to file documents, especially in the Supreme Court clerk's office. If you have a notice of appeal due, go ahead and file that, because when my staff goes back in full time, we will be processing things on a first come, first served basis. And so if you get your documents filed, they will be taken care of first in line, and you'll be forwarding your case along for your client. I also want to point out that once the deadlines go back into play and the stay is lifted, the plan is not to have everything due on one day, okay? The deadlines are going to gradually go back in place so that the deadlines that were stayed in March will be those that are first addressed and have a new deadline put on them. And then the ones that were due in April and were suspended will then have a deadline after that, okay? So I know I've gotten those questions, but keep in mind, you can go ahead and file things now because we are open. Now, Justice Walker told you about something that, and she was really the guiding force behind this happening. You can see now I've shared the screen with you of the court's website, and that is courtswv.gov. This is a website that as a lawyer, you should frequent often. You can see right here, we have all of the COVID-19 documents here. Okay, so any of the orders that the chief and Justice Hutchison were talking about, those are all right here if you click on this link. But what I want to show you today is our calendar and docket from the homepage. When you go to our calendar and docket, you can see what is docketed for each month. Now, I hope all of you know that West Virginia was one of the few states that was able to go forward with oral arguments during this time. And we had oral arguments remotely on April the 14th and April the 15th. And we're going to have them again here in 2 weeks on May 19th and May 20th. And those will also be done remotely. But what we've done during this time, see, we have up here that all cases were argued remotely. They are still webcast, okay? So remotely, one of my employees ran the webcast from the courtroom, and they were all broadcast. All the justices at that time had the background that Justice Hutchison has right now, which made it look like they were in the courtroom and gave it a more professional look. But we have an order in place that talks about what I'm going to show you. So although all of the oral arguments are webcast live, those have never been available in the recorded method. So you couldn't go back and look at an oral argument that took place before. That has changed now. So the first oral arguments that have been recorded and are up here are the ones from the April docket. So you can see there is an icon here for the oral arguments that were recorded. And when you click on that icon, it will take you to the YouTube station showing you the recordings. So it is connecting here. First case for oral argument today is going to be argued. You can see in Ray, DJ, and LJ, docket number 190388, and presenting the argument for the petitioner is Stephen Mancini. Okay, so that just shows you that shows you something that we did during the break. We're going to backfill.
Let me thank everyone for
it takes a minute for that to go off. But we're going to now backfill, so we have the most recent oral argument up there, and then we can backfill back to the start of this term. So as of January 20th, 2020, all of those oral arguments are going to be put up there, and you can now go back and look at the oral arguments that have been recorded. You'll notice there under the terms of use, the Supreme Court is not a court of record. So this is not an official record of the proceedings. We also are not following official archiving. So that's all included in the terms of use, but those are some exciting things that we are doing. And speaking of doing things remotely, you know, to this point, I've had to just, before the oral argument, train the lawyers for how to use the remote equipment and be able to present the oral argument remotely. But our technology staff under Pat Moat's direction has put together some webinars for all of the lawyers. And as more of the circuit courts are going to be doing more matters remotely, because keep in mind, even when you can go back into the courtroom, if you have something that maybe makes you more susceptible and you want to do your matter remotely, you can ask for that. And we are encouraging people who can work remotely to continue to do that. So there will be webinars given through the State Bar. The information will be on the Bar Blast, and you can get CLA credits for those also, and they are in the law office and management area. So if you need the training on how to do remote hearings, those will be available to you. So Justice Walker, with that, I think I covered what you needed me to on this subject.
Well, thank you, Edie. And I am very excited about our beginning to make our oral argument recordings available after the fact. We know that folks have been out there recording them for some time anyway, so we thought, well, we should make them available. So that's a very exciting thing. One kind of fun story from our remote arguments, where so far we haven't had any glitches today. Of course, our first argument, we had a little bit of a glitch. But my favorite part was when one of the advocates was very competently making her argument doing a very nice job, as they all did. And this was brand new territory for everybody. I was so impressed with how they all did. But you could hear in the background someone say, "Mommy," and you could see on her face that she clearly had someone watching her child, but she was hopeful. You could tell. She carried on, but you knew that she was doing her best, as all of you have been doing under sometimes challenging circumstances, balancing homeschooling and lawyering and everything else. So now, as we're not winding down, but coming to the point in the webinar you've all been waiting for. We've been teasing this the whole time. I'm now going to turn it over to the chief. We have an order that I think may be entered today or tomorrow or sometime this week that's going to answer a lot of the questions we have received so far about what happens next. So Chief, I'll turn it over to you.
All right, well, thank you. And, you know, I was kind of laughing as well about, we have learned, everyone who has dogs, cats, children, you know, all the remote technology has allowed us, you know, you'll be in a very serious argument and then someone's dog will start barking or something. And it's a new world for all of us, but we certainly have, I think everyone has been improvising and moving forward very well throughout this process. But looking forward, we mentioned that we are working on trying, let me give you an example or an analogy that Judge Moats from Taylor County used with me this week as we were talking through some things. He said, you know, the engine of our courts, it's not stopped, but it has slowed somewhat over the last couple of months. And as we start to rev that engine again, we're going to need to do that a little bit gradually. There will be need as Edie has said, we have stayed some deadlines and we will have an order addressing how those deadlines, they won't all become due. Some may become due on May 18th when the order that currently is in place expires, but others will be spread out. And so that we don't have everyone filing everything on May 18th. Which would be a tremendous amount of work for all of our clerk and clerks throughout the state to deal with. But the second thing we want to do is to gradually start reopening our courts to in-person proceedings. As everyone has said, we have never closed our courts, but we have converted them to a more remote technology format. And we'll still want to use that as much as possible. And I want to stress that is we still want to use remote technology and video conferencing as much as possible moving forward, even though we'll be able to start having some in-person proceedings. But what we're looking at, and this is subject to a number of factors. One, we've been working very closely with our health officials. This is the key to all this is to do it responsibly in a way where we protect the health and safety of our citizens while we move forward. So we've been talking with Dr. Marsh, with medical officials from the National Guard, with our DHHR officials. We've been trying to make sure that we're compliant with the directions of the governor in terms of stay-at-home orders and various directives. And we want to continue to do that. So this will, even though we are going to put in place an order, it will still be a work in progress. We will be still reviewing it each and every day. And if we need to pull back on any of these factors, we will certainly do that. So I think everyone has become used to working on a day-by-day basis or a week-by-week basis. So while we're going to put forward what we believe is a reasonable plan for moving forward, we also want everyone to understand that this will need to be versatile in terms of how we may have to pull back or modify it as we go forward. But first of all, what we're going to do is to start doing things more gradually. The first thing we're going to start reopening is we're going to restart reopening the courts to in-person hearings, not trials immediately, but in-person hearings. So it's our plan, unless something has changed in terms of the health direction that we're receiving, to start having in-person hearings at the expiration of the current order. And so those would be able to start on May 18th. So those will also be done two qualifiers on that. First of all, certain counties in our state are still designated as hotspot counties because of the nature and the number of cases that are still active in those counties and new cases reported. So in those hotspot counties, as designated by DHHR and the governor, we will not be proceeding with in-person hearings immediately. In those counties that are going to be considered green counties, green is in to go forward, we're going to be able to move forward, but with very strict guidelines for social distancing, for wearing of masks in those hearings, for other areas where we may be reshuffling the way the courtroom looks. Some of these, as Justice Hutchinson has mentioned, may take place in other courtrooms or other facilities. So we're going to provide, and also as Justice Walker said, we're going to provide sort of the blueprint, the overall blueprint, but we are going to rely upon our judges throughout the state to be creative in certain things that they need to do to be able to ensure that these guidelines are followed. And they've been very responsive to doing so and very successful in doing so up to this point. And we have great confidence in their ability to do that moving forward. The second step of this rollout will be starting on June 15th, we're going to allow grand juries to proceed. And so we know that that's been a very important topic to our judges as we work through this. They are very eager to start those processes again. And so we will, it will be our plan that on June 15th, we will begin grand juries. And then if everything proceeds as we hope it does, we will be able to start jury trials once again on June 29th. So that is our hope, that's our plan, that is what we intend to enter in terms of an order. Again, we ask that everyone keep in mind two things. One, we hope that you will work with us in terms of ensuring that the order is complied with, the guidelines that are included in this order, certain protocols to ensure the safety of people in the courtroom. We're going to ask you as the bar to help ensure that your clients are compliant in these matters when they go into the courtrooms, and that all parties are compliant and respect the need to continue a number of these safeguards. But also, we also, again, want to reiterate, these things may change depending on the circumstances in our state. And so we will continue to monitor it on a daily basis, but that's sort of the overview of what we believe will help us start. So we're to start the process of having in-person proceedings once again in our courts.
Thank you, Chief. One of the main questions we're getting, and I'll let either Edie or the Chief field this, is a little bit more about what happens with these deadlines. Chief, you mentioned that, you know, all the deadlines aren't going to come due all at once, and I see Edie's unmuted, and maybe she can start and then you can add to it, Chief. What happens to deadlines? For example, one question that's come in is, if a complaint and discovery was served during the judicial emergency and the response is due on or before the 15th, does the responsive time limit begin on the 15th, or is the response due on the 15th? And that's the gist of some of the other questions we're getting. And Edie, while we can't give specific advice in every case, I'll let you comment on what we anticipate doing here in another day or two.
Certainly. So Justice Walker, as you know, my office helps people hourly with procedural questions, and I consider this to be a procedural question, so we can help. So as the Chief said, not everything is going to come due on the 18th, okay? So there is going to be a category in the order. For instance, anything that would be due, that was due sometime in March, and the date will be set forth in the order, then that will be the first group of cases that has a new deadline assigned to it. So for instance, the question that was asked, I think it was that the deadline, a complaint was filed and a deadline for filing an answer and some discovery is coming up maybe on May the 13th or 14th. So that would fall in the May category of cases, and those will have a specific due date set forth in the order. So it won't be day by day, but the clump of cases that were continued or stayed during the first part of the stay that was put in place, the March stay, that group of cases will have a new deadline. And then the group of cases that had a deadline in April or May, those will have a deadline after that. Okay. So again, like first come, first serve, we're reinstating deadlines, and they will go in a sequential order. If that helps answer the question.
Yeah, I think it does. Chief, do you want to add anything to that?
Yes, the only thing I would add is that there will be some deadlines that will be actually when this order is rescinded or not renewed, but there will be some deadlines that will be due immediately after that. So you'll need to look very carefully at this order and make sure that you comply, particularly with statutes of limitation. There's a difference between how we're going to deal with statutes of limitation and statutes of repose versus court deadlines for responding to briefs and other deadlines like that. So we're actually still discussing certain deadlines of how we can make that work the most effectively for our clerks throughout the state. And so we will have very specific guidelines in the order.
Well, great. Another question that's come in several different forms via email. It comes in a term in the form of questions or just expressed concerns about, will there be masks in the courtrooms? Will there be social distancing? What about litigants or lawyers who are either in a compromised immune situation or otherwise have concerns about being able to attend in person? And I'll kick this off, and then maybe I'll ask Hutch to comment, and then the chief. Let me start by saying that, nothing changes if folks have a physical condition, mental condition, whatever it is. The Americans with Disabilities Act remains in effect. If you need reasonable accommodation, that's your responsibility, either on behalf of yourself or your client, to ask for it. So nothing changes in regard to that, but also, of course, we are listening to health experts, as the chief said, and we have been told that the single best way to avoid the transmission of COVID-19 is for folks to have masks and to stay 6 feet apart. And so we are certainly, we've talked about how we're going to get masks out to the courthouses. We have talked about all of those issues, and we will continue to talk about them. But Hutch, do you want to add to that? And just from the point of view of a former circuit judge and these kinds of concerns that people legitimately have about coming to court, even if hearings begin, as the chief mentioned, on May 18th.
Absolutely. I've talked to some of my friends out in the circuits when we were doing this, and even when we were limiting the types of hearings that could be held to abuse and neglect preliminary hearings and criminal first appearances and arraignments and that sort of stuff, they were talking about having to have folks in the courtroom and lawyers being concerned that, hey, I don't know this client. I've just been appointed to represent this client, and how do I protect myself? And the order absolutely is going to require the use of masks. And one of the things the order does is it puts on the attorney, and so you need to know that, those of you listening in today need to know that one of the things we're expecting is that you can convey to your clients the fact that if they're coming to court, they need to bring a mask with them. And any mask that covers the face, anything that's appropriate will be acceptable. We're not gonna, we would hope that they wouldn't have masks that have questionable writing on them, but in any event, we hope that you understand. Now, understanding that there are going to be lots of situations where folks are going to show up in court either without counsel or not having had an opportunity to appropriately communicate with counsel before they have an initial hearing of some type. And the court, will be supplying emergency stores of masks to each of the circuits, trying to figure out how to get that done right now. but we recognize that not everybody's going to comply with our request. And so before they come in the courtroom, they're either going to have a mask, or we're going to give them one and have them put it on. So there are lots of concerns, practical concerns that judges have that have been communicated not only by their staffs, but also the lawyers that are appearing in front of them. Little issues, look, I'm vulnerable, and I've got folks at home that are vulnerable, and that term is defined, by the way, in the order. A vulnerable person is defined. You need to understand that what we are suggesting is that in-person hearings can take place, but we are still encouraging everybody to use remote hearing technology, either Skype for Business or whatever is available to the folks, to try and continue to do that as much as you can. And we're encouraging the circuit judges to help with that, recognizing that just because we say you can go back, not everybody's going to feel comfortable going back.
Those are great points, Hutch. And of course, our conversation about these masks, we understand the importance of them. As I said, they're one of the key defense mechanisms, but it's going to be part of the new normal in our world that folks are going to, take some responsibility for their own masks. And we want to be gentle about this. We want to have expectations that you and your clients take care of yourselves, but we recognize that for indigent clients and folks, coming out of the jails or wherever, we're looking at all of those contingencies. And for someone who asked on the email, will people be turned away because they don't have a mask? And the answer is, we're going to try to do everything we can to make sure that doesn't happen. But Chief, do you want to add to that?
The only other thing that I would say is, and I think everyone has touched on it, that this is going to be sort of all of our responsibilities to ensure that these guidelines are followed. So as you read these guidelines, please prepare your clients as well for what's going to happen in the courtroom, and that they should wear a mask when they go. And I know that there's questions. One comment that I've heard is, we need to make sure not only people are safe, but that they feel safe. And I think that's important. So we're going to we hope that the courts that throughout the state, that our county commissions, our courts, will use the time leading up to when we start reopening these to make sure their courtrooms are sanitized and clean, that all the facilities are clean. And the guidelines will also require cleaning between each of the hearings, so that there are certain responsibilities that will be done in between each of these hearings, so that people are not only are safe, but feel safe as well, and know that these things are being addressed.
That's a great point. Go ahead, Hutch.
Right. There's one other point that I wanted to make sure everybody understood, was that the order also directs there be no cattle calls. No coming in and 4,500 people standing in the hallway waiting to get into the courtroom. We were encouraging our judges to absolutely not do that, and to give actual times and come up with methods of waiting in your car and getting a call from the secretary saying, hey, come on in, it's your turn now, that kind of stuff, and being able to adapt hearings that way. So we're trying to give some overall guidelines, but it's going to be, as Chief said, it's the responsibility of everybody to try and prepare everybody else to come into these kinds of hearings.
And you raise a great point, Hutch, and Edie can't wait to talk about it. I'll set it up for her, this issue of waiting, and whether we're talking about waiting in magistrate court or waiting in circuit court, cattle calls, scheduling conference that still take place around the state. I think all of that's going to change, and it has to change given what we've been through. But one thing we also recognize at the Supreme Court is that we tell everyone to arrive at 10 o'clock, regardless of when your argument is scheduled. So Edie, do you want to shed some more light on that?
I would love to. So before I do, I have to thank the leadership of this court. Many of you know that I've been at the court for a long time, and the leadership through this is just unparalleled, okay? And a lot of changes are made, and a lot of them are really good changes that have come about from this situation. And in a lot of areas, I'm not going back to the way that things were done before. And something that we're always asked about is on oral argument day, we do have kind of a cattle call. All of the cases are set, and we tell everyone to be there at 10 o'clock. Starting with the fall term, because I told you that the May oral arguments will be done remotely, but hopefully by the fall term, we will be back physically in the beautiful Capitol in our courtroom, and the cases are going to be set at varied times, okay? We're gonna estimate when it is. So not everyone has to come anymore at 10 o'clock. So if you're maybe the fourth case on the docket, you'll be given a more realistic time of when you should appear in the courtroom for your oral argument. So, you know, once again, these justices are leaders, and in telling the circuit judges, family courts, and the magistrates not to have cattle calls, they are going to be doing the same thing also. So that's the news on that front that I had to share, and thank you.
Well, thanks, Edie. That is exciting news, and we think it's going to allow for a little smoother. We understand it may cut into a little bit of billable time for some of you, and we apologize for that. But I think overall it's going to be great. Now I see it as 11:02, and we've already exceeded our time, and I'm surprised Anita hasn't jumped in to make sure we knew that. But I am watching the time, and there are a lot of things that we haven't been able to cover yet. There will be news coming out about these specific deadlines, probably, as the chief said, within the next few days. There will be news in the very near future about the bar exam. That's something that we didn't have a chance to cover today, but Edie has been literally talking to people about the bar exam every day since this all started. And we have also received some questions about Court Plus and e-filing, and obviously that project has been paused, but will pick itself back up, and we'll talk more about that in the future as well. So it's been my pleasure to moderate this great gathering. Thank you all for being here. Thank you to my colleagues, Chief Justice Tim Armstead and Justice John Hutchinson, for doing this, and our amazing court clerk, Edie. If you have sent email questions, I will make sure they get answered one way or the other. And if we, in consultation with the State Bar, figure out that it would be productive to do another one of these on down the road, we'll certainly look at that. So thank you all for attending. Continue to stay safe and healthy. This has been a challenging time for all, and we hope that, and we'll continue to work to make our courts accessible, but also safe for everyone.